I was hurt. I don't understand. Why can't you take my case? We get this call at least a couple of times a week. Someone is injured. They're frustrated. They're upset. And they've called 5 or 6 different attorneys. Everybody's telling them some version of the same thing, which is, unfortunately, we can't help you in this case. And that's super frustrating to hear. But why? Why in North Carolina periodically do you get attorneys that just can't help you? And you're like, look, I got hurt. I've got medical expenses. I got a mess. Why can't you help me in this particular case? And it gets a little bit deep, but let me see if I can walk through it a little bit. Again, my name is Joe Tunstall. I've been doing personal injury work for 22, 23 years, whatever it is, here in Eastern North Carolina and Raleigh area. One of the big things we have to contend with in North Carolina is something called contributory negligence, which means that if you are potentially a reason for your injury, it makes it very difficult because that is an issue that will go to a jury in North Carolina. There's only 5 states that have that. We're 4 states in I think DC that has that. The second issue is, in a lot of cases, we need to front a lot of cost up front. So we had a call today. Someone really needed some help, and I think it's a legitimate injury. They got hurt. Unfortunately, they're going to need somewhere in the $10,000 to $20,000 worth of expert work. Their injury probably has a value of, I don't know, $5,000 or $10,000. So the question is, and they were upset, and I get that. Why can't you help me? Why can't you take my case anyway? The defendant should be responsible for these costs. The issue is they're not. And at the end of the case, we try the case to a jury. The defendant is only responsible for the cost in the case that the expert is actually testifying live for. So the $10,000 worth of the expert coming out to the scene and drawing up all the different pieces and putting together all the super complex pieces to this case, we don't get reimbursed at all for that, and nor do you. So either my client has to front that cost, or if they can't, we'd have to front that cost. So that can't happen in every case. And in fact, it can only happen when it makes sense financially for that to happen. So when folks call us and say, well, you just won't go up against this, whatever they'll list everybody. You just don't want to go up against them. And the answer is, I have no problems going up against anybody, except for my wife. She's about 5'2" and redhead, and she scares the hell out of me sometimes. And I'm not going up against her. With regard to everybody else in the world, I'm not really scared of anybody, but financially, I can't go explain to a client that we should go spend $25,000 when they're going to get 10 back at the end of the day. It just doesn't make any sense. It doesn't make any sense for the attorney. It doesn't make any sense for the client. And most of my clients don't want to go spend $20,000 of their own pocket while they're already hurt, missing work and everything else, when they're not going to get that back. So I hope I explained a little bit about why in some cases when folks call us, we just can't take the case. The other part we have is contributory negligence. So in North Carolina, if you are 1% at fault, then you don't have recovery. It's not quite, that's what defense attorneys like to say, it's not quite that way. It's if your own injury is found to be a contributing factor in your own negligence is a contributing factor in your injury. And what that means is, if you and the other side were both partially at fault, and the jury thinks that you're 10% at fault, and that was what caused this wreck, you're not going to recover. So that's one of the things we have to look at is, at the end of the day, does our client have a chance of recovering? If they don't have any chance of recovering, or if it's a very low chance, we have to be smart about that. I don't want to tell a client let me go work on your case for 3 years. I don't think you can recover anything. It's not good for my firm. It's not good for you from an emotional standpoint. So very often, it's not necessarily ripping a Band-Aid off, but we just tell them up front, unfortunately, there's this bad law called Contribute North Carolina, and as a result of that, we just can't help. So those are 2 of the questions we get on a very regular basis, just about every week. And some folks really, they just don't get that. They really don't understand the cost. So last piece of this video, let me just kind of explain a little bit. If you hire an accident reconstructionist and that accident reconstructionist goes out to the scene and does an initial look for evidence, takes pictures, uses this really cool camera that spins around and takes measurements of everything down to the centimeter or millimeter, you're going to spend $2,500 to $5,000. I mean, it's just right out of pocket, right off the bat. That's before the person's been deposed, before they finish doing their work. The attorney or the client, depending, will have $5,000 to $10,000 worth of cost before they even know really what's going on with the case. And in contingent fee work, what I do, where I don't get paid on, but by the result, I often have to pick up the phone and call a client and say, look, we sent them out there and they've looked at everything, and I'll be honest with you, this is not going to go anywhere good. And then the clients don't want to reimburse you for $5,000 worth of work. Or let's say we need a medical expert and we call a doctor. If you think your doctor is expensive when you go to them during the week, you ought to call one up and say, hey, can you look at a legal case for me? All of a sudden the rate goes from $100 an hour to $500 to $1,000 to $1,500 to $2,000 an hour to look at medical records, talk to your client, and make an opinion. Again, you can have $10,000 or $15,000 or $20,000 in costs very, very, very quickly in one of these cases. So for most of us, we're very picky about what cases we take and what cases we don't. And as a result of that, sometimes our clients get very, very frustrated, or potential clients get very, very frustrated because we just say, I just can't do it in this case. So that's one of the things that we're always very cognizant of and very careful with, and we're trying our absolute best to make sure that if we get involved, that we're with you all the way to the end of the case. And if we don't get involved, there's usually a pretty good reason. And we tell folks all the time, I tell folks all the time when they call and say, look, if the attorney's not willing to spend $10,000 in the case, that ought to give you a pretty good idea what's going on. If I'm unwilling to go spend the cost on the case because I don't see the benefit at the end of the day, there's no point getting frustrated with the attorney, because if I, from a business standpoint, could do that, I would. Again, my name is Joe Tunstall. Just wanted to briefly hit on an issue where we get a lot of calls every week. I've been practicing law for 23 years here in Eastern North Carolina with O'Malley Tunstall. Thanks.